You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And excited for another conversation today. We've been talking about, quite a bit, David, judicial supremacy.
Right.
And a lot of discussion on the 14th Amendment. And while we're going to navigate a bit away from that conversation, we've been talking about, the court doesn't make laws, and these major Supreme Court cases such as Obergefell and Roe v. Wade, which has obviously had a great deal of impact culturally, legally, all over the country. And we've talked about, we've treated those things as a law, not simply as judgments.
Right.
But today, so Supreme Court hears a case,
right,
and the Supreme Court makes their judgment.
Right.
Now, what do we do with that? What does that mean? Can it be challenged? Is it there forever? And I think that's an important discussion to have, because many people are under the assumption not only that, like we've been discussing, that this judgment somehow is being interpreted as law,
right,
but I think people also have the perception that, Supreme Court's ruled.
It's over.
That's it.
Supremacy Clause, right?
Yes.
We've talked about that too.
Yeah.
Right.
Well, also, but also in the fact that there's no change in this. That's just the way things are now.
Right.
But the truth is that things change all the time.
Sure.
Not only do their own opinions change,
right,
but the court also changes. The makeup of the court physically changes, from time, which again changes opinions.
That's right.
So
actually, I think Jim Bopp, in the hearing in August, I don't know if he said this or not, but the Supreme Court has reversed its precedent at least 250 times.
Wow. I do remember something like that.
Yeah. So it's kind of like, well, if that's just the law, mm-hmm, and it's just the way it is, or it's just the Constitution now, well, how did they reverse themselves? Something had to happen, mm-hmm, to reverse themselves.
Right.
And that's what I want us to look at today, is that when the court says a state law about marriage is unconstitutional, is that just the end of it? Or when the court says you can't have this abortion law, is that the end of it? And we have some very fascinating stuff today to look at. And it's particularly germane because just this week, I think it was this week, maybe it was last week now, but the governor announced one of his legislative proposals will be to deal with abortion.
Right.
So we need to know how to think about what he will propose eventually.
Yeah.
Then I think it was maybe 2 weeks ago, the Supreme Court heard oral arguments in another abortion case that came out of the Fifth Circuit.
Out of Louisiana, right?
Yeah. And so I hope today we can help you understand why right to life's attorneys were opposed to a heartbeat bill, mm-hmm, and how the Supreme Court operates flowing out of how that case was argued 2 weeks ago in front of the United States Supreme Court. It'll give you a little peek behind the curtain of Oz,
yep,
to see what you have to do to get a case in front of the Supreme Court and get it in a posture where it can be reversed.
And it's an interesting case to mention that we're going to talk about today, because I love what you highlighted to me earlier. We're talking about this Fifth Circuit case, right, about the Louisiana law.
Right. It's June Medical Services versus G.
Right.
Right.
So it's the law where a doctor that's going to perform an abortion would be legally required to have admitting privileges to a hospital.
That's right.
Yeah.
That's right.
Which seems like it would be a pretty reasonable law.
Sure, yeah.
But that's not part of the discussion today.
Yeah.
But I found what's interesting about the case currently being held, looked at by the Fifth Circuit and now the Supreme Court, is that it's eerily similar to a case that happened in Texas
that the Fifth Circuit heard.
That the Fifth Circuit heard not so long ago. So I'll let you get more into that. But before we do, I want to talk about, because we're going to sort of base our discussion on this quote that you found from Justice Scalia that was from a prior case, actually on marriage,
right,
U.S. versus Windsor. But it was Justice Scalia had something very interesting to say, because he felt in this particular decision in Windsor that the court had based their opinions on just kind of silliness and not really on.
They were all over the board,
all over the place
Right.
on making their opinion. And so Scalia looked at that and he said, look, an opinion with such scattershot rationales as this one, federalism noises among them, can be distinguished in many ways and deserves to be. State and lower federal courts should take the court, capital C court, at its word and distinguish away. In other words, shouldn't be afraid to challenge this thing. And when you've got just because the Supreme Court has made a ruling, doesn't mean that you don't come back and make just such a distinction, right? Where you can now bring that case and force them to reconsider it again.
That's right. That's right.
He's inviting, hey, don't just, to all you states and people out there,
right?
Don't just take this at face value.
Right.
If it's an issue, here's what you do: deal with it, bring it back to the court. And he says, and you should.
Yeah, you should distinguish it.
Yeah.
That you ruled on vanilla ice cream. Well, I now have chocolate. Well, that may or may not overrule the ruling about vanilla ice cream. But what he's saying is, chocolate's a different flavor ice cream. Bring me that. Mm-hmm. I might reverse my ruling about vanilla.
Yeah.
So distinguish away. Figure out, well, okay, this time I'm going to talk about pizza.
All of a sudden, you've given me chocolate, and now vanilla's not so fancy.
Yeah, or you gave me pizza, and I really like pizza, so I'm going to overrule the case about ice cream and say no, pizza should be the law.
Yeah.
Or we're going to do hamburgers next. So he's saying distinguish what we've had. Every case, this is where it comes back to, every case is about a particular case or controversy. That's all the court decides. So if your statute is based upon a different rationale, so think about abortion. If you go to the Supreme Court and say, we accept your 14th Amendment jurisprudence about when an unborn human being becomes a person, well, okay, if you accept that, the court's liable to not overrule it. But if you come over here and say, but we have a different rationale than was used in that case, our rationale is based upon the Ninth Amendment and the rights people kept over here. Now I've distinguished my law from your law because you based your law on the 14th Amendment. I based mine on the Ninth Amendment. You've now distinguished them. Thank you. You gave me something else to look at. You've now given me a different legal argument, and I haven't addressed it. The fact that I answered the question under the 14th Amendment does not bind my ability to answer the question under the Ninth Amendment. They're different constitutional provisions. So this Fifth Circuit case that the Supreme Court just heard an argument on is very, very important.
And real quick, and I'm sorry to interrupt, but
go ahead.
But I feel like, this popped into my head because you spoke at an event a couple of evenings ago, and whenever you said this, I saw the light bulbs go on for a lot of people. So
right.
I just want to, as we're talking about distinguishing and things that the court's looking for, I just want to say something about in reference to the heartbeat bill, because we had a heartbeat bill, then we didn't have a heartbeat bill, and now we might have a heartbeat bill, and so and where is the distinguishing factor? And the question always is from the pro-life movement in general, well, what's going to get to the Supreme Court? At the end of the day, we want to save babies' lives, pragmatically. That's a good and right thing to do, but the question always remains, well, what is it that gets to the heart of Roe v. Wade? When do we get to the Supreme Court, and when do they reconsider that ruling? And that's what we're about to get into are these distinguishing factors. And one of the things you just said, I think it's important to clear up our stance on the debate of the heartbeat bill, that not only, like you said, that you've brought out, but that Bob, Jim Bob, on behalf of National Right to Life, who was against our prior bill, who brought out as well, the fact that heartbeat bills, essentially, when you boil it down, they make an indistinguishable argument from that which has already been made. In other words, it accepts this 14th Amendment jurisprudence. It accepts the ruling and the premise of Roe in the sense that all the court did was assign an arbitrary point to life. Well, when does life in the womb become life? Well, we don't really know. So we're going to say, at the end of the second trimester or whatever
Roe,
it is.
It was the third trimester.
The third, and then, so what heartbeat bills do is they accept that premise and say, hey, we agree with your arbitrariness of ascribing life, but we just want to do it earlier. So we like 12 weeks, we like 6 weeks, we like 20 weeks. And so we're working within the same notion of arbitrariness to life. And lastly, I just think it's worth pointing out, to my knowledge, I don't think the Supreme Court has ever heard a case on a heartbeat bill. Every heartbeat bill, I believe that someone may want to fact check this.
No, that's true.
But I believe that every heartbeat bill that has been passed by every state has been enjoined by a court,
right?
And then has not gone any further. It's never, maybe it's gone to a circuit court, but it's never gone to the Supreme Court. Now that I wanted to say that because in this conversation we're about to have on distinguishing, well, why wouldn't the Supreme Court hear that argument? Because we have not distinguished it from the ruling that's already been made in Roe v. Wade.
Yeah.
In Roe v. Wade. So,
that's right.
So that's what we're talking about today is how do you get the court to reconsider a point, which is exactly what's happening in this Fifth Circuit court case.
That's right.
Go for it.
Yeah. So what is fascinating about this case that was just argued in the United States Supreme Court a couple of weeks ago, June Medical Equipment versus G, is that the Fifth Circuit decided another case, almost exactly like it in terms of its verbiage, that said doctors in Texas instead of Louisiana had to have admitting privileges. And the Fifth Circuit upheld that law, said, I think it's good. I don't think it violates Roe versus Wade. It does not provide an undue burden on the woman's right to have an abortion. And the Supreme Court took the case, and then they reversed the Fifth Circuit and said, you got it wrong. Well, a lot of people took that as a blow to the abortion situation. But Louisiana's bill came up to the same court, Fifth Circuit. It had the same principle that doctors have to have admitting privileges. And the Fifth Circuit didn't really ignore it, but they distinguished the decision in the other case, Whole Women's Health versus Hellerstedt, and said, I know you struck down our decision on the Texas law, but we're going to distinguish the Louisiana law from the Texas law, and we're going to just do it again. And so there's a classic case of saying that the circuit courts themselves, so for instance, the Sixth Circuit on marriage, the Sixth Circuit on abortion, they could say, I know what the court's held, but there's just enough difference here that I'm going to do what I think is right. And I'm going to make you have to hear my case. And read what the Fifth Circuit said when it upheld the law in Louisiana after being spanked by the Supreme Court over the Texas law.
Yeah, well,
here's what they said.
Yeah, so essentially they said there's no evidence that any of the clinics will close as a result of the act. So they're giving all this, they're defending.
Well, let's start right up here at the top. About Whole Women's Health, yeah.
Ooh, okay, long quote. On remand for consideration in light of Whole Women's Health versus Hellerstedt, the district court invalidated the act as facially unconstitutional.
Right.
The court overlooked that the facts in the instant case are remarkably different. So in their
let's
opinion,
stop right there. Let's stop right there. So what happened is that the Supreme Court ruled in Whole Women's Health. The federal district court now in Louisiana says, oh, well, I see what the Supreme Court said. I guess I better follow it. Mm-hmm. And the Fifth Circuit...
So the lower court upheld the Supreme Court's decision.
Yeah, and said the Louisiana law is unconstitutional. The Fifth Circuit said, no, we really like these laws. We're going to find a way to distinguish. So he said, here's what you did, federal district judge in Louisiana. You overlooked something.
Yep. And so they went on to explain here in Louisiana, unlike in Texas, the act does not impose a substantial burden on a large fraction of women as they had determined in Whole Woman's Health and other controlling Supreme Court authority. Careful review of the record reveals stark differences between the record before us and that which the court considered in that previous case.
That's right. So they're distinguishing. What the Supreme Court said in Whole Women's Health.
They're following Justice Scalia's advice.
They're following his advice and saying, I'm pro-life, and I'm going to distinguish every case I can and make you reverse me. Now, I think that's just fascinating. It's not like this was a decision of the Supreme Court in the Third Circuit, and now we've got the Fifth Circuit. This is the very same circuit.
We're still in the same circuit.
That the Supreme Court smacked down in Whole Women's Health, and they say, I saw your smackdown, but I don't agree with you, so I'm going to find a distinction, and I'm going to uphold my law. Watch that. Now, that's important because they made distinctions. But now here is a critical thing. The Fifth Circuit, in the case that was just argued, accepted that Roe and Casey was still good law. You'll notice they said, well, the Supreme Court said in Whole Women's Health a couple of years ago that you cannot put an undue burden on a woman's opportunity to have an abortion. And that's what Roe and Casey said. And you said that's still the standard as long as there's not a viable fetus, that can survive outside the womb. And y'all thought that the specific facts in the Texas situation did create an undue burden. But we're going to accept that that's what you said. But in Louisiana, it's not an undue burden because it's not as big a state. And most doctors are required by law to have admitting privileges anyway, whereas in Texas they didn't, and so on and so forth. So lots of distinctions, and we're going to uphold our law again. Now, one of the things that Jim Bopp said that I confess I didn't fully appreciate, and I'm the one that has the quote here. He said this in a couple of ways. He says, if you want to challenge Roe, every law that has passed is an opportunity to overturn Roe. It's not necessary to pass a prohibition on abortion to challenge the court to overturn Roe. So it doesn't need to be a heartbeat bill, a personhood bill, or a 15-week ban for the court to overturn Roe. They're the Supreme Court. They can do whatever they want to do. But he said, bills like this, heartbeat, personhood, 15-week ban, all have downsides. One, they'll never go into effect in the meantime. So they'll be enjoined by the district court.
Immediately.
Yeah, and probably by the Sixth Circuit. Now here's where I would distinguish a rule of law type approach through the Ninth Amendment versus a heartbeat bill. If you go in and argue to the Sixth Circuit, no, our ban is not based upon Roe or Casey and us not violating Roe or Casey. Ours is based under a whole different constitutional provision. Who knows? The Sixth Circuit, which has already indicated Roe is stupid, might say, oh, wait a minute, just like the Fifth Circuit, you gave me something different to look at.
Right.
I like that. I'm willing to do that. So you can't assume the Sixth Circuit on a Rule of Law Life Act wouldn't do exactly what the Fifth Circuit did after they had gotten smacked down 2 years earlier by the Supreme Court. They said, wait. I heard what you said, but they're talking about something else here. They're not talking about the 14th Amendment. They're talking about the Ninth Amendment. And
Supreme Court, you've not ruled.
And you've not ever ruled on that.
Yeah.
That's right. So, but he goes on. He says, so here's the second part. The court is loath to take a case that leaves them with a stark choice when the only way to uphold the law is to reverse Roe. In other words, the court really doesn't want to reverse Roe, so don't put them in that posture. But they could. But here's the important point. He said this, the court is more likely to grant certiorari, to hear a case, grant an appeal, regarding a non-prohibitory law which is what the governor wants to include, ultrasounds, or you can't abort a baby because of its sex or because it has, physical disabilities. He says the court's much more likely to grant that because that would be a new kind of thing. Well, is a sex selection okay? Or what about a birth defect? Or what about, an ultrasound law? Maybe we hadn't ruled on those yet. And all those will serve as a suitable vehicle to re-examine Roe. And then he makes this important statement. If the court is willing. Mm-hmm. Now, I confess I missed the if, but the if is huge. And here's why it's huge. One of the things that Paul Linton, who testified against the heartbeat bill back in April and again in August. Yeah, and again in August, is he said this, the heartbeat bill, as it passed in the House, he said, for reasons we've discussed, it would violate the existing federal, standard, never go into effect, would never save a single unborn child, but this is the key, and would never be reviewed by the United States Supreme Court.
Which it hasn't.
Which it hasn't, and he's noted that. You've had all these other heartbeat bills. They've not been reviewed. There's no indication the court wants to hear those bills. But I thought, it's a little audacious to sit here and say the Supreme Court will never hear. You don't know what they'll do. You just testified that any case is an opportunity to reverse Roe, but his point was well made that I missed. If you go back to the Supreme Court asking them to answer a question they've been answering for 47 years, the odds are they're not going to be willing to answer it if you don't give them a different question.
Right.
Okay. Now, one of the things I had not appreciated, I knew in the back of my head, but I hadn't hooked it together with what Mr. Linton was saying. When you apply to the Supreme Court, you can say, we would like for you to rule on a heartbeat ban, a 20-week ban, a 22-week ban, an ultrasound bill, a fetal selection bill, a sex selection bill, a birth abnormality bill, and blah, 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 blah. But the Supreme Court decides what it wants to hear. And it tells you the question they want you to address. When you tell them what question you want to hear as the Supreme Court, you don't get to say, well, I appreciate you would like to hear my answer to that question, but this is the one I want to talk about. They'll say, I'm not interested in that. You come up here in my oral argument and you start talking about a question about Roe, and I didn't ask you to talk about Roe. Shut up, sit down. You need to answer the question I asked. Now, here is the question that was asked in the Fifth Circuit case that was heard a couple of weeks ago. The question the court wanted the parties to address is very narrow and very limited, and it indicates that the Supreme Court is not interested in revisiting Roe or Casey. Now, the question
in this case.
Yeah. And here's the question the Supreme Court asked. Right there. Just read that part.
Says whether the Fifth Circuit's decision upholding Louisiana's law requiring physicians who perform abortions to have admitting privileges at a local hospital conflicts with this court's binding precedent in Whole Woman's Health. This was my question.
Yeah. Well, that was the question.
Well, that you had posed.
That's the question I posed. So the Supreme Court asked this question. Does the Fifth Circuit's ruling in June Medical Services conflict with our ruling in Whole Women's Health a couple of years earlier? Did you hear anything in there about Roe versus Wade?
No, not at all.
Does it say we want to know if this creates a right to life in a child? Does it say we want to know if we should reverse Roe versus Wade? No. They're assuming. So I sent that question to 3 constitutional law professors that I know. And I said, does this question essentially mean the court probably will not reconsider Roe or Casey? They all said, you're right. They probably won't. Now, one of them is a good friend of mine I've known for, 20 years maybe, Jerry Bradley. He's taught constitutional law at Notre Dame for 27 years, 9 years before that at the University of Illinois. He's published nationally and internationally. And I asked him, what do you think the court will do? So here's what now he's Catholic and he's very pro-life. He writes on it prolifically. And here's what he said, by asking this question, this narrow, limited question, here's what I think will happen.
He said, yes, the court could and probably will affirm the Fifth Circuit, thus more or less overruling the specific holding in Holman's Health, and say nothing further of importance about Roe or Casey.
Right, that last part. They may reverse Whole Women's Health and uphold the law in Louisiana, but they will likely say nothing about Roe or Casey.
Well, because in the case before them, they don't have to.
That's right.
So why you haven't put them in a position where they have to address it.
That's right. So why am I going to address it?
They will almost always likely choose to not deal with it.
Yeah, and by phrasing the question they wanted you to address, they signal to you, I don't want to talk about this. Mm-hmm. You haven't given me the kind of case I want to talk about this, so I'm not. And so I'll look for a way to uphold your law without having to address Roe and Casey.
Right.
And that's going to be true. That's what Bopp and Linton were saying about heartbeat bills and really any bill. The Supreme Court does not have to hear them, and they will hear what they want to hear about the issue they want to hear about, and you have no control over that. Now here's what's fascinating. I'm working on another issue dealing with marriage. So in talking with some of my constitutional law professors who clerked on the circuit courts of appeals right below the United States Supreme Court, they both have friends on the United States Supreme Court that are law clerks and been law clerks. And they said, David, what you want to do to get heard in the Supreme Court is to file, in their words, a rifle shot kind of lawsuit. Don't go up and say, well, what about this law, and what about this law, and what about this law, and what about that law? Because they may not hear the thing you want to hear. And so you're hoping when you file 6 different kinds of attacks on abortion that they might hear all 6. They may only want to hear one. And so it's very possible that they will hear a case dealing with sex selection abortions, but they don't want to hear a heartbeat bill. So that part of the law might well never passed it.
If you give them a buffet to look at, they're going to pick
what they want to eat.
Right.
That's right. And so they said if you pass a bill that's narrow, that is so narrow, and or the basis of the bill is so narrow they can't escape it, then you're more likely to have them hear it, because they're either not going to hear the case or they're going to have to hear it. That's it. And they can't reword the question. So let me give you an example. You're working up the budget for our organization. Mm-hmm. And the board could say to me, David, did you have any input in the budget? And I could say, yeah. And be honest. I gave you all the prior year's budget, showed you how we did them, and then I never looked at it after that. Okay, if they ask me, though, the question, did you review the budget that Gary put together that you're now presenting to me and review all of his numbers? I'd say, oh, no, I didn't do that. Now, I am going to do that. But my point, you see, is that based upon the question you ask, you're going to get a different answer.
Right.
And so when the Supreme Court says, I want you to answer this question, is the Fifth Circuit ruling in June Medical Services in conflict with Hellerstedt? They are saying to you, I'm not asking you if it's in conflict with Roe versus Wade. I'm not going to revisit that question. That's why Jerry Bradley said, at best, they'll uphold the law, overrule Hellerstedt, but leave Roe and Casey intact. And so it's very, very important, I think, that I didn't appreciate what what Mr. Bopp and Linton were saying, and to the extent that I said things that implied that was crazy. Now, I disagree with their views of judicial supremacy and reliance on court precedent and so on and so forth, and don't dare distinguish too much.
Yeah, we're dealing with the court is always about politics.
Yeah. So, but I do agree that you can't make the Supreme Court hear any case, and you can't even make them answer the question you want them to answer if you don't make the bill so narrowly tailored that the only question they can ask is the one you want answered. Now, let me tie this back up and we can wrap up this session. But back in September, the state went to trial in federal district court over its 48-hour waiting period law that the legislature passed back in like 2015, I think it was. And the state, I talked to the attorney who handled the case, bright attorney, good attorney. I'm sure he did a great job. But I said, are y'all challenging Roe and Casey? Are you arguing our 48-hour waiting period is good law because Casey and Roe are bad law? And he said, no. We are assuming that Roe and Casey are good law. But we just didn't do an undue burden. Now, see, that's what the Fifth Circuit was saying.
That's what they're doing here in this Holman's Health
They're
case.
saying, undue burden, I get it. Hellerstedt said just undue burden. But I'm not, this time I'm going to say there's no undue burden. And I'm going to give you the reasons.
Yeah.
So if you don't ask the question at the trial court, if you don't put Roe and Casey at issue in the trial court, the odds of the Supreme Court wanting to answer a question you never even asked goes way down.
Right.
And that's where I think the pro-life community needs to decide, do we want to just kind of keep chipping away, and we'll see if in another 8 or 10 or 12 or 15 years we have the right number of judges and the right judges and then we win? Or do we want to say, let's take a whole different attack. Let's take a whole different approach. Let's put this on a collision course with a question the court has never heard before.
And my question with that point of view is always, well, chipping away at what? Because there's quite a bit of conversation now today that, look, if you're pro-life, then you are against killing babies, not just for killing less babies. Does that make sense?
Fewer babies.
Yeah.
You're also not for saying the Supreme Court decides when you become a person.
Yeah.
See, if all you do is uphold a law, but you don't get Roe and Casey reversed, you've left the power in the hands of 9 judges to decide at what point you stop being a potential person and actually become a person. I don't think the Supreme Court should decide that. That's not their decision. From a Christian perspective, God made me a person the moment the sperm hit the egg, and I was a person. Now I'm going to become a bigger person, stronger person, I hope, a smarter person. But I was a person. If I wasn't a person when I started, I will never be a person. That's kind of like saying, a lamb chop's going to become a sirloin steak. Mm-hmm. It didn't have cow in it to begin with. Right. It can't become a cow.
Yeah.
So I don't like the idea of saying to the Supreme Court, oh yeah, you still get to decide when a person is a person and what constitutes a person. No, God established that. From the moment of conception, he said, you are a person. Now, I want to be careful here. I'm not talking about personhood bills. I'm not talking about a personhood amendment to the Constitution. All I'm saying is that the government, under common law principles, has the duty to protect rights, particularly rights that come from God. They can fail in those duties. They can protect those rights to some degrees and not to other degrees. So I'm not arguing here for a personhood bill or a personhood constitutional amendment like some would do. I'm taking a lesser approach to that. I'm not saying that that's a bad approach, but I am saying the first thing we can do is ask our government to protect the rights that we were given by God. And one of those rights is our right to life. And at the common law, they said that the life extended to the child in the mother's womb. And they acknowledged that the reason that right extended there is because it was given by God. Now, that's a biblical thing I can argue for without having to argue, well, I'm for trying to save more babies, but I really don't care about the principle. And so I just kind of close with this statement. We all want, well, I shouldn't say we all want, but I know the governor wants, I want, the majority of the legislature wants a culture of life. But you don't get a culture of life without acknowledging the source of life.
That's good, yeah.
And so I like an approach that says, I'm going to take a different tact. I'm going to go from a different direction against Roe versus Wade. I'm going to raise a question you've never asked. I'm going to create a distinction that's never been in front of you. And I'm going to rest it in the kind of law and understanding of law that is consistent with the notion that the Supreme Court does not give me being.
Right.
God gives me being. As Paul said to the philosophers on Mars Hill, it's in him we live and move and have our being, not when the Supreme Court decides I have my being.
Yeah.
And that's what's on my heart. That's why I care so deeply about this issue. And I trust in the coming days, well, I have an opportunity to provide those thoughts to the governor and that he'll take those into consideration. And then whatever he does, he does. But those are my thoughts. And
well, and they're solid thoughts. And I'll just, I want to say this, kind of leave everyone with something to think about. And I know when I say this, people are going to say, oh, that's crazy. It's radical. That'll never happen. But look, there's a lot of things going on in our culture right now and in law being considered that we thought were crazy 20 years ago that would never happen. I mean, the fact that we don't know what men and women are anymore, and we're non-binary, and we're changing birth certificates and all, all this sort of stuff. So you made a statement back in August in your testimony before at the summer study, and you said, it was basically the end, and you talked about laying the axe to the diseased root. And
yeah, in April, I think it was.
Yeah. Well, you repeated it in August because I remember being there. And I just want to leave us with this thought, as crazy as it may seem, that we need to take, as people, we should not relinquish and be okay with the fact that currently, with Roe v. Wade in place, we've given the federal government the right to determine when we are people, albeit currently in the womb. But if they have that right to begin with, then how is it not at some point in the unknown future that right could be extrapolated beyond the womb? I mean, we are already, I mean, infanticide is already being talked about.
Sure.
Going back to Governor Northam in Virginia and
New York.
New York. I mean, that's already there. So we're already out of the womb and having the discussion. So as my brain works, as I think about, well, and I only say this because there's been so much discussion about people with Down syndrome and being aborted, which I think is a horrendous thought to even have. I think we are all immaculately created by our Creator with divine purpose. And so with that in mind, at what point is someone with Down syndrome, or perhaps with a certain disease that disables them from being cared for, and perhaps they don't have family, they become a burden to the state, at
or
what
just get too old?
At what point are you too old or too sick or too disabled, where the law all of a sudden does not consider you a person deserving of constitutional protections anymore, and decides that you're no longer considered viable, this word we use in our abortion language. All these questions start to pop into my head. If Roe v. Wade stays intact, and the the idea of ascribing, like you said, I love how you said, a baby is not a human becoming.
Yeah, it's a human being.
It's a human being.
Yeah.
But if we consider that a becoming and the state gets to decide when it's a being, then it would stand to reason that, well, it can make that decision at any point, not just in the womb. Why not out of the womb? If law is just positive law, if we don't have God-given rights, if we don't have inalienable rights endowed to us by our Creator, if everything does come from the Supreme Court, if everything does come from the federal government, then truly, what is unthinkable?
Yeah, I mean, why could the court not say you have being and existence as long as you're self-supporting?
Yeah, but the moment the moment we got to start paying for you or whatever.
Yeah.
Well, it's just.
Or
you're out of luck.
Yeah, you're out of luck. So these are very, very deep questions, and we need to think them through. And I think as Christians, we need to address them based not on pragmatism but principle. Mm-hmm. And that's where we will get a culture of life, because we'll testify to the truth about the nature of life, and that it is all sacred, it is all valuable, and so there's only one objective point at which to determine that when you're conceived. So anyway, the point is people need to understand
final thought.
Courts distinguish cases all the time, but you've got to distinguish it on the correct ground, and you've got to distinguish it in a way that the court, if it's going to hear the case, will hear the case you want them to hear. And we'll look forward to see what the court does with the June medical decision when that comes out probably this summer.
That'll be a really interesting decision to watch, and we'll make sure to keep you posted.
Sure.
Thanks again for joining. As always, if you have any ideas, questions, comments, we'd love to hear them. You can send those to info@factn.org. Thanks for listening.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's factennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.